All right. Our next case is Banker and Anderson versus Wilmington Trust.
Your Honors, may it please the Court, my name is Moses DeWitt and I represent the appellants Nicole Banker and Frank Anderson. I'd like to reserve 8 minutes for rebuttal, please. The appellants respectfully request that this Court reverse the final judgment entered on June 23, 2017, and remand to the trial court with instructions that the January 17, 2008 final judgment shall stand. As Your Honors are aware, the trial court lacked jurisdiction in this matter to enter the amended final judgment. The first final judgment was entered in 2008, then they tried to amend in 2013, and then they've now amended again, theoretically, in 2017.
So if you're correct, does the 2008 judgment come back into being?
I believe so, Your Honor, because the second amended final judgment was void, and the court.
So I'm trying to understand, where does that get you? Your clients purchased the property from the debtor 3 years after the 2008 judgment.
So
they wouldn't have even had a right to intervene because they took it with knowledge of or at least constructive knowledge of the foreclosure, so they lose anyway. I'm trying to understand what the fight's really about.
So as far as these proceedings are, Your Honor, our clients are technically just the tenants because, yes, they don't have a right to intervene. There was a quitclaim deed that's entered. I'm not even sure if that's really part of the record in this case, to be honest with you. My clients want to.
It must be. We all know about it.
I guess it is part of the record then. My client's endgame is they want to be able to purchase the property from the plaintiff or the appellee in this matter. Again, a little outside of the record there. But the real issue.
The bottom line, I guess, is even if you win, even if we say, okay, the 2017 judgment is no good and the 2008 judgment is, I mean, you're still out of luck, aren't you?
To a degree. I mean, the first judgment and the second judgment nearly doubled, and I think the first judgment was about $500,000, the second judgment was nearly $1 million, and there's attorney's fees and everything else that they're going to ask my client to reimburse them for, which I don't believe they have a right to do. So that's the first issue there. The second issue is merely just a matter of title.
But even if your clients take the position that the 2008 judgment is there, it's still, you've still got 8% interest or whatever the statutory interest rate that's accrued on the unpaid judgment since then. I mean, it seems like the number is still mighty big. I mean, you may be able to quibble a little bit about it, but I'm just trying to understand what the fight's really about.
Well, I think that really is where the fight probably lies. It's probably gotten a little lost in the sight of both sides, frankly, over kind of what the technicalities of this case are. Frankly, I don't think there's any dispute here that the plaintiff filed this case in the name of the wrong plaintiff. If they hadn't, they wouldn't go back for 2 amended final judgments. Certificate of title was issued in 2013. They would just assign that certificate of title to their new successor interest.
Well, at the time of the 2008 judgment, though, all the defendants had been defaulted, so nobody contested it. Regardless of who the plaintiff was, everybody's rights were wiped out, correct?
Correct, but a default only admits well-pled allegations. And in this case, they got a judgment in the name of the wrong person or the wrong entity.
And who appealed that judgment?
Well, no one appealed that judgment. That judgment stands. Our position is the 2008 judgment stands.
At what point during the litigation did your clients object to the court entering a new judgment?
Well, my recollection is they filed a motion to amend the judgment, and then they filed a notice of voluntary dismissal the next day, the plaintiffs did. That's when my clients
Back
intervened.
in the 2013 range.
Correct.
Right?
That was about mid-2013.
Right, but then the litigation began anew at some point that resulted in the 2017 judgment?
Well, then the amended final judgment was then overturned, and then there was a hearing, and one of the judges entered an order, because there's been multiple judges throughout this case, saying the original final judgment is also thrown out. So that gave the plaintiff, the appellee, the green light to then basically relitigate the whole case. However, the case law is very clear that the second amended final judgment was void because it was entered 5 years later.
My question was, when did your client say, no, there should not be a new judgment, let's go back to 2008? I didn't see that being a litigated issue, a defense, anything that your client raised during the litigation.
Oh, that was raised many times, Your Honor. It was raised when they tried to amend the final judgment. It was raised early in 2013. So there's numerous...
Talking about after that point. After 2013, there's a whole nother trial, correct?
There's a whole other trial, and that was...
During that whole nother trial, that's when your client actively participated, correct?
Correct, Your Honor. We were...
And at what point during this whole nother trial did your client say, no, you don't have any power, you don't have jurisdiction to consider this?
They didn't because they were told they were not allowed to raise that defense at that time.
They did not, in
They
any
did
way.
not. Which, it's very clear, Your Honor,
You
first
say they were
DCA...
told. Where did they try to and the court wouldn't let them?
That was back when the judge issued the order saying we're back to the original final judgment. The original final judgment from 2008 is thrown out, and we're basically starting anew. And so then we were left basically just to defend the case on its merits at that point because the judge had already made a decision. That's where this case was headed. Even though we disagreed with the position, obviously we couldn't just sit back and say we're not going to defend the case on its merits at that point because there's still a huge standing issue. I mean, they can't prove standing at inception if you really want to go into that. That's not before this court today. But it's clear that it's fundamental error. The first DCA has specifically stated it's fundamental error, which can be raised for the first time on appeal. The second DCA, which cites Wright v. Scott, has said even if no one raises it, the appellate court can raise it. Same fact pattern here. It is absolutely fundamental error. We didn't have to raise it below, even though I believe we did numerous times. And
Tell me where it was raised.
it was raised on our...
How about after 2013? Did you appeal from the 2013 ruling?
No, that's part of our appeal here today, Your Honor. And so, but I think the appellee's argument that that was somehow waived or invited error, if you read through the quotes that they make here, and I believe one of them is at record site 366, if you read that whole motion is saying Wilmington is not listed on the final judgment. And when they say final judgment, it was really amended final judgment. They kind of misquote us there. The amended final judgment was clearly thrown out, which then meant that Wilmington could not get a certificate of title because they didn't have a final judgment in their name. The final judgment in this matter is Citibank N.A. as trustee, but they failed to list the trust. So huge error there. And like I said, had this just been a simple transfer of title or transfer of successor interest like they claim, which I'm very surprised they haven't conceded that point at this point in the litigation, they would have just taken that certificate of title, which is still there from 2013, transferred it over to their new interest like they do on a million other foreclosure cases, and we wouldn't be here. There's clearly an issue here that's a little bit deeper that they're really not disclosing to the court, in my opinion. But I think the case law is very, very clear that this is fundamental error. They had a judgment in 2008, then they go back in 2013. Someone wasn't talking because they tried to amend and then they tried to dismiss within a day of each other. And then that amended final judgment gets thrown out. And then they say, okay, now we're just going to relitigate the whole case again. And so a case that really ended in 2008 went all the way to 2017. I just really don't know how you get around the jurisdictional issue here. I think it's pretty clear that we did not invite the error in any manner. Our client certainly didn't invite the error. We had a judgment in 2008. They're going to try to blame us for the delay, but frankly, we're the one who just pointed out the issue to the court. You really can't blame our party for pointing out an issue to the court that they created. Finally, the first time they ever tried to fix this matter was 5 years after the original judgment was entered. The court just simply doesn't have jurisdiction. They're stuck with the original final judgment. The property was sold, on a certificate of title was issued January 28th of 2013. That's never been overturned. I mean, we have a foreclosure judgment, a sale, and a certificate of title, and then they want to go back and relitigate the whole thing all over again. I just don't think that's proper, Your Honor. And I'll reserve the rest of my time for rebuttal unless there's any additional questions.
May it please the court, my name is Terrace McGovern. I represent the appellee. This is a 2007 mortgage foreclosure action where the loan's been in default for 11 years.
Who was the plaintiff in 2007?
The plaintiff in 2007 was Citibank, NA, as trustee.
And your contention is that wasn't the right plaintiff?
That was the correct plaintiff at the time, Your Honor. Citibank, NA, was the trustee for the trust in 2007.
Why didn't you just assign the bid or assign the certificate of title to the new trust and we're good to go? I mean, I just don't understand what this whole fight's about.
And Your Honor, I agree with that to a certain extent. I don't understand why this issue has come up now on appeal.
It's come up on appeal because you all tried to amend the judgment.
Well,
Years and years and years later.
that's correct, Your Honor. We did try to amend the judgment years later, and it was amended. And that amended judgment took the place of that 2008 judgment.
Well, that presupposes that the court had jurisdiction to amend it.
Well, Your Honor, the court had procedural jurisdiction.
Which section of Rule 1.540 do you rely on to amend the final judgment?
Well, it'd be Section B, Your Honor.
How much time do you have to make that the type of amendment that you're looking at?
You have 1 year to amend under 1.540B unless you're raising that the judgment is void or there's been some other equities.
Right, and you're not suggesting that the judgment was void.
No, Your Honor.
So I guess I'm trying to understand the timeliness and why, again, I go back, why didn't you just do the easy thing, which is assign the certificate of title or quitclaim the property over to the right trustee?
And I can't really answer that for Your Honor. I don't know why that method wasn't used. But what happens is procedural jurisdiction, even if it's done in error, if it's not addressed timely, it's waived. And this court has held that procedural jurisdiction can be waived. We have in U.S. Bank versus Anthony Irish, where an order was entered on an untimely 1.540 motion, and this court held that that order wasn't void because procedural jurisdiction can be waived. And the Fourth District agrees with that. MCR funding says that if you don't raise the court's procedural jurisdiction, you do in fact waive it. It's different than subject matter jurisdiction. Subject matter jurisdiction can be raised at any time. But procedural jurisdiction is a different type of jurisdiction, and it has to be raised below or it's waived. And that's part of the issue that we have here is the tenants didn't raise the issue below, that the court lacked procedural jurisdiction. And in fact, what they say at the record page 367, paragraph 18, they say the plaintiff fails to state that the final judgment was set aside, which voided the sale and certificate of title that may have been issued. The only way that sale and certificate of title could have been voided was if that 2008 judgment were also gone, because the sale and certificate of title occurred months prior to that amended judgment being entered. And then the lower court they adopted that reasoning that there's no judgment in place, because when that amended judgment was entered, whether it was procedural error or not, when the amended judgment was entered, it superseded that original 2008 judgment so that that 2008 judgment ceased to exist for any purpose. And once that amended judgment was vacated, it didn't revive that stale 2008 judgment. So the lower court clarified at the record, page 462, there's no judgment in place. And that's exactly what the tenants asserted, that there was no judgment in place. And after that clarifying order, the tenants didn't file a motion for reconsideration and say, hey, court, you don't have procedural jurisdiction to be doing this. They didn't file a petition for writ of prohibition. They didn't do anything. And because that 2008 judgment was set aside, the tenants were put in a beneficial position to be able to stay in the home, to litigate the bank standing to foreclose, and it was advantageous to them. They were able to stay there for an additional 4 years without the mortgage being paid. And that's part of how they invited the error. Was they suggested to the lower court that there was no judgment, that the final judgment was vacated, which voided the sale and certificate of title. And then the lower court adopted that reasoning. And
Of course, in the Anthony Irish case, we said that the bank waited 4 years. We went into a big discussion about procedural jurisdiction. And then we said, well, they waited 4 years and that's too long. I mean, in this case, you waited from 2008 until 2013 to do anything. I mean, I'm not sure, at least if you look at the facts of Anthony Irish, how that really helps you.
well, so Anthony Irish, the borrower there, filed an untimely letter, but the court considered it as a motion to vacate. But it was beyond the 1 year, and it didn't allege that the final judgment was void. The court entered an order vacating the final judgment and entered a dismissal in that case, beyond the 1 year. And then the bank came in several years later and said, well, that order of dismissal, the order that granted that motion to vacate, was void. And the court said, well, that order may have been entered based on some procedural error, but it wasn't void. And back to the tenants inviting the error, the law says you can't invite the error below and then take advantage of that error on appeal. Had the tenants been successful below in their standing argument that they raised throughout the litigation, then they wouldn't be here today challenging the court's jurisdiction on a judgment in their favor. And the law simply doesn't permit this heads I win, tails you lose strategy. The tenants are also judicially estopped from asserting the position that they take now, because below, they assert there's no judgment in place. And they say that's in the record at page 367. And now they're saying, well, actually, there is a judgment in place. The 2008 judgment is still in place. And Judge Orfinger, you actually addressed this in re adoption of DPP, and you said, a party who accepts the benefit of an order is estopped from urging error on that same order. So the tenants accepted the benefit of that clarifying order that said there was no judgment in place. Because again, they've been living in the property, they haven't been paying the mortgage, it's been an advantageous position for them to be in. But now they're urging that that order, that clarifying order that Judge Thompson issued in 2015, that there was no judgment in place, they're saying that that order was entered in error.
How was the issue of judicial estoppel raised either below or in your brief?
Well, we addressed the issue of estoppel in the brief, Your Honor. We said that the tenants were estopped from taking this position because they had taken a contrary position below. And I think it just goes back to all the ways in which the tenants failed to really set this up. They waived the procedural jurisdiction argument. They also invited the court to enter this clarifying order that said there was no judgment in place. And then they are barred by estoppel because they're taking one position below, and now they're taking a different position on appeal. And there's also no fundamental error here, because fundamental error actually arises in the context where the court lacks subject matter jurisdiction or where there's been a denial of due process. And we know that the lower court had subject matter jurisdiction, and the tenants haven't raised any issue with denial of due process. So this isn't about a fundamental error issue. And Your Honors, even if this 2017 judgment is reversed and the bank is left with the 2008 judgment, alternatively, we ask that the court uphold the order granting the substitution of party plaintiff. And the court has the inherent authority to enforce its orders. There's federal cases that say post-judgment, a party should be permitted to substitute party plaintiff to ensure that judgments are properly enforced when there's been a transfer of interest. The federal rule 25C mirrors the state rule 1.260C. And if you look at those federal cases as authority, they certainly support the bank being able to substitute party plaintiff after judgment. Do your honors have any further questions for me?
No, thank you.
Your honors, I would like to ask that the 2017 judgment be affirmed, and in the alternative, if the court does reverse the 2017 judgment, I would ask that the order granting substitution of party plaintiff be upheld. Thank you.
Thank you, Your Honors. I'd like to take issue with the statement of Record Site 367 when they're stating that we argued the final judgment was set aside, which voided the sale and certificate of title that may have been issued. If you read that motion, that's a motion to vacate order for alias writ of possession. And the very next line states, the plaintiff's claim is completely devoid of a legal or factual basis for allowing an alias writ to be issued to Wilmington Trust, N.A. as successor trustee, and goes on to explain that the amended final judgment was set aside. They're taking one line out of the record and completely misconstruing it for their argument. It's very clear here. All through 2013, we argued the amended final judgment was void. The 2008 final judgment's in place. Then we got an order that said there's no final judgment in place, so we proceeded as necessary from that point. Further, Your Honors, it's important to note that the plaintiff below, the appellee here, never cited Rule 1.540 as to how they were trying to amend this the entire time. They said that they were the successor in interest. And when they're standing here before the court asking the court to allow them to substitute the party plaintiff after the final judgment, they're completely ignoring that a certificate of title was issued in 2013 at this point. They have certificate of title. The certificate of title was issued to Citibank N.A. as trustee. Again, the problem is there's no underlying trust listed. So they can't transfer it properly like you normally would. If any company changes names and they have a final judgment, that final judgment is an asset of that corporation. They just assign it on over. They transfer it over. There should be no issue with that. It's very clear here there's an underlying deeper issue as to why that can't be done and why all this litigation took place. Frankly, the corrective issue that they should have done way back in 2013 was either do a re-foreclosure or file a quiet title action to clear their title. They tried to take this route for some reason, and that's what got us here today. As far as the substantive versus procedural due process argument, when you look at the case law on this matter, the Wright v. Scott case out of the first DCA doesn't do a distinction. And the case there is a very similar fact pattern to this one. I believe that's where they tried to add the defendant after the final judgment. And the court said, no, it's a substantive change, you can't do that. Here, it's a substantive change, they're trying to change the name of the plaintiff. They don't state whether it's procedural or substantive jurisdiction. They just say it's a fundamental error which can be raised for the first time on appeal. Romero v. Wells Fargo, 209 Southern 3rd, 633, they again cite the Wright v. Scott case for the very same proposition, that you can bring it for the first time on appeal, and that's the case that actually says even if no one brings it on appeal, the appellate court can still bring it. So I believe the substantive versus procedural due process is really a red herring here. It's fundamental error. There's a judgment from 2008. It stands. After the 1 year mark, they've never even pled 1.540. They never pled whether it's 540A, 540B, how they're asking for a change or an amendment to the final judgment. Frankly, there's just nothing in the record to support an amendment whatsoever. To date, the sale and the certificate of title have not been set aside. They've been sitting there the entire time from 2013. No one's ever moved to set those aside. Citibank N.A. as trustee still holds title to the property as far as I'm concerned. So I think it's very clear here that from a jurisdictional standpoint, you just can't do what they want to do. And I understand Judge Orfinger's question as to what's really the bone of contention here. And while I wish I had a better answer to that, I think it really just boils down to the law is what the law is. And at the end of the day, you can't go back and amend a final judgment 5 years later because you messed up originally, frankly.
Is there any evidence in the record that would be able to demonstrate to us that the trust, that Citibank was the trustee for this same trust, and now it's Wilmington Trust?
I don't believe there could be, Your Honor, because they never listed the original trust. So,
Well, I don't know that that's necessary. I mean, I think it's sufficient if they say as trustee. I mean, you can argue about, I suppose, who they're trustee for, but it was, in their motion to amend the judgment, did they say in there that we're the successor trustee to this trust, or?
in the 2013 amendment, that's when they first alleged that Wilmington Trust, or Wilmington was the successor trustee to this trust. I believe it was in the 2013 motion for amendment. And that's the first time it was raised, was post-judgment. So there was never anything pre-judgment as to what trust actually held the note and mortgage in this matter.
Okay.
So, Your Honors, we'd ask that you reverse the 2017 final judgment, even though it's really an amended final judgment, and have the 2008 final judgment stand, as I believe the case law is very clear that any final judgment entered after the 1 year period is void for lack of jurisdiction. That is fundamental error.
All right, thank you.
Thank you, Your Honors.
We'll go ahead and take a short break, and those attorneys who would like to can meet us in the Lawyers Lounge for coffee.